Last week, the Supreme Court granted a writ of certiorari before judgment in Biden v. Nebraska, which will determine the legality of the president's student loan debt relief program. What this means is that the court will hear this case on the merits before it makes its way through lower federal courts of appeal. This is unusual. Traditionally, the Supreme Court hears a case only after it has gone through a federal trial court, the district court, and a federal appeals court, except for cases where it has original jurisdiction. As the legal scholar Steve Vladek notes in an article on this subject in his Substack newsletter, the long-standing statutory and normative preference is for appeals to be taken only after final judgments, i.e., when all of the factual and legal issues have been resolved to the maximum extent possible. As the Supreme Court itself has often said in its own opinions, it is a court of review, not first view. In 1925, Congress explicitly gave the Supreme Court the power to be a court of first view as part of a package of reforms meant to reduce the court's workload. But in keeping with tradition, it used this authority sparingly. From 1925 to 1988, the court issued certiorari before judgment in just a handful of the cases it heard during that period. And from 1988, when Congress made additional reforms to the Supreme Court's appellate jurisdiction, to 2019, the court granted certiorari before judgment in 3 cases: Clark v. Romer in 1991, Gratz v. Bollinger in 2002 and United States v. Fanfan in 2004. Biden v. Nebraska marks the 18th time since 2019 that the court has granted certiorari before judgment. It is, as Vladek writes, a remarkable shift. He hazards a few guesses as to why the court has made this change. Perhaps it is a response to the rise of nationwide injunctions from district courts, although this accounts for only 5 of the 18 cases in which the court has granted certiorari before judgment. Perhaps it is a response to the rise of state lawsuits against the federal government, although, again, only a few of the cases involve the states as plaintiffs. Or maybe it's just a sign that the justices are in a hurry and have a lower bar when it comes to the kind of emergency that justifies such an early-stage intervention. There is another possibility. According to Mark A. Lemley, a law professor at Stanford, the Roberts Court, with its conservative majority, is an imperial Supreme Court, undermining the power and authority of the other branches of government, as well as weakening the power of lower courts to act and make decisions. The court, Lemley writes, has taken significant, simultaneous steps to restrict the power of Congress, the administrative state, the states, and the lower federal courts. It gets its way, he continues, not by giving power to an entity whose political predilections are aligned with the justice's own, but by undercutting the ability of any entity to do something the justices don't like. In the case of administrative agencies, this means a new, extra-constitutional test, the major questions doctrine, that seems to be designed to allow the court to reject significant agency actions that are within their grant of power but that the agency implements in ways the court doesn't like, such as, Lemley notes, in West Virginia v. E.P.A., which limited the agency's power to protect the environment. In the case of Congress, this means rulings that restrict congressional power to create new causes of action, for people to seek legal redress for forms of injury Congress might recognize with legislation, and rulings that restrict the ability of Congress to create new executive agencies with independent leadership,